If you're considering starting a business in California, one of the key decisions you'll need to make is how to structure your company. One popular option is to form a limited liability company, an LLC. LLCs provide their owners, known as members, with limited personal liability protection, meaning that their business assets are generally protected from creditors and other claimants. Today, we'll explore what personal liability protection means for an LLC members and when it might not apply. I'm attorney Andrew Bethel, and thank you so much for watching. If you find this video helpful, please hit the like button, and if you want to see more, please subscribe and ring the bell. Of course, leave a comment below if you have any questions or have a topic you want me to cover. Your comment might be featured in a future Q&A. Personal liability protection is a key benefit of forming an LLC. When you form an LLC, you create a separate legal entity that can do things separately from you. It can enter into contracts, sue or be sued, and own assets in its own name. This means that if the LLC incurs debt or is sued, the creditors and claimants can only go after the assets of that LLC, not the personal assets of the members. This protects the members' personal assets, such as their homes, cars, and bank accounts, from being seized or garnished to pay the LLC's debts or obligations. Next, let's discuss when this liability might not apply, because after all, if the main benefit of an LLC is personal protection and separation, you need to know when it won't apply, so you know how to not let that happen and better protect yourself. Keep in mind that some of these may blend into one another and could fall under the blanket piercing of the corporate veil, which I'll mention, but I think it's easier to understand when you think about each individually. The exceptions to personal liability protection in an LLC include, at number 1, personal guarantees. If a member personally guarantees a debt or loan of the LLC, then they may be held personally liable for repayment. Number 2, illegal activities. If a member engages in illegal activities on behalf of the LLC, they may be held personally liable for any damages resulting from those activities. Number 3, gross negligence or misconduct. If a member acts with gross negligence or misconduct, they may be held personally liable for any harm caused to others. Number 4, piercing the corporate veil. In rare cases, a court may pierce the corporate veil and hold a member personally liable for the LLC's debts or obligations if the LLC was not properly formed or operated. The next points can trigger corporate veil piercing. Number 5, undercapitalization. If an LLC is undercapitalized, meaning not enough money invested in it at the start, thus being unable to meet its financial obligations, a court may hold that the members are personally liable. How much is not enough? The court just wants to see that a reasonable investment was made based on the intended business activities. Number 6, fraudulent transfers. If a member transfers assets to the LLC with the intent to defraud creditors, a court may disregard the limited liability protection and hold that member personally liable. Number 7, unlawful distributions. If an LLC makes an unlawful distribution, such as paying out benefits to members instead of using them to pay debts, a court may hold that the members are personally liable for the LLC's debts. Number 8, failure to observe formalities. If an LLC does not observe proper formalities, such as holding regular meetings, keeping proper records, or following the provisions of its own operating agreement, a court may disregard the limited liability protection and hold the members personally liable. Number 9, commingling of business assets and members' personal assets. This is exactly what it sounds like, mixing business with personal. An example is paying private debts with business funds. And lastly, number 10, alter ego theory, where the LLC has been so utilized by the members that no separate entity has been maintained between the members and the LLC, or where the dominant member has mined the LLC of its capital, thereby preventing it from accumulating capital to meet expanding business needs. It's important to note that these circumstances are relatively rare, and personal liability protection for the members of an LLC can be maintained by proper formation, compliance with legal and tax requirements, and careful record keeping. Another point to keep in mind is what impact the tax classification election has on the personal liability protection in LLCs. The election for an LLC does not directly affect what personal liability protection is in place for the members. Whether an LLC is taxed as a sole proprietorship, partnership, S Corp, or C Corp, the personal liability protection for its members remains the same, meaning that their personal assets are generally protected from creditors and other claimants. However, the tax classification election may affect the tax consequences for the LLC and its members, such as the amount and types of taxes the LLC must pay, and the way the profits and losses are reported on the members' individual tax returns. Of course, it's important to consult with an attorney or tax professional to determine the best tax classification for your LLC, considering your specific business goals and financial circumstances. Click here to check out our previous video, or check out this other great video.